Now, if I know anything at all about non-competition agreements and trade secrets, it's only because I learned it from Dan Barnhart, because I never learned it any other way. And as far as I'm concerned, Dan knows everything, absolutely everything about non-competition agreements and trade secrets, and he's come today to help us answer a number of questions, including those of a sort our colleague Emily Schultz asked on the streets of Portland. So here are Emily's on the street interviews, and then Dan's wisdom. You'll find Dan's PowerPoint slides behind tab 5 of your binder.
Hi, I'm Emily Schultz, and we're out today on the streets of Portland asking folks about questions you'll hear in today's briefing. Do you know what a non-compete agreement is?
No, sorry.
So can any employer make their employees sign a non-compete agreement?
I do not know that.
What about, like, if I'm a barista? Can my employer make me not make lattes for anybody else?
That would seem silly.
I don't know. Do you know what a non-compete agreement is?
Yes, no, yes. I guess so. So if you leave to go to a competing firm that you don't divulge any information to them, right?
And that's it for us. Back to you guys in the studio.
Good morning. Thank you for coming back from that second break. You guys are the true believers out there. Thank you for coming back for this. So non-compete agreements, trade secrets, confidentiality agreements. What are we trying to protect? These are the things that you can legally protect. Relationships is the primary focus. Your client relationships, your customer relationships, sometimes your relationships with vendors as well. Trade secret information, confidential business information, whether it be financial, whether it be a customer list or customer histories or how much you charge customers or your profitability with customers. You can have agreements to protect your reputation, like non-disparagement provisions. And every employer has property that they need to protect, whether it would be their data, their documents, forms, keys, laptops. These are the type of things we litigate about when it comes to non-compete agreements. And I put up this slide of this castle, this sort of storybook castle from England, to illustrate the point that protecting these things requires various layers of protections. You've got your killing field out there, you've got your moat, you've got your first set of walls, your second set of higher walls, your keeps. It requires you to use multiple strategies to protect this information, not just non-compete agreements. The tools that every employer should use involve the basics. Good screening. Who are you hiring? Have you done a background check? What are you entrusting these people with? Effective management. You may have these policies. You got to use them effectively. You got to manage people properly. Make sure they're abiding by your expectations, keeping them accountable, developing a culture of loyalty and integrity. And there's some outside standards that apply to a lot of organizations, professional standards, whether you're an accountant, a doctor, an HR manager. You have your own set of standards and ethics that you're expected to follow. You use these outside rules many times in non-compete litigation to demonstrate the standard that should be expected of employees. The other things you can control are your handbooks and your policies. You have a safety net with some laws that protect you, common law and statutory law. And then finally and foremost, the thing I do the most, contracts. The opportunity to draft your own law, if you will, to protect the things that the law allows you to protect. Now, the problem with relying on the fuzzy things, good management practices, screening, things like that, they're essential. You've got to do it. But the problem with relying on something like that is there's always somebody who's going to try to get past those barriers. You can't completely rely on culture because a bad apple is going to come into your organization at some point in time. And for those who you need to worry about the most, trust in a culture and good management can sometimes be the weakest link in the chain. Handbooks and policies. This is the one area where you get your lawyers involved. They're an awesome tool, but in general, they only apply while the employment relationship still exists. And your remedies are therefore limited to employment-related remedies for the most part. You can discipline them, you can terminate them, you can suspend them, you can change their compensation. If they violate some of the rules that you have in place, whether it be your data security policy, whether they've taken confidential information home when they're not supposed to, whether they've been accessing computer files that they shouldn't have had access to. You have employment-related remedies available. But usually, practically always, your handbook is not a contract, or at least it shouldn't be. If you look at the very beginning of every handbook that you have, in the preamble, at least if this firm drafted it in all likelihood, the preamble or introduction, there will be a statement that says, this is not a contract, it's just a guideline. I've seen plenty of non-compete cases where people pull out their contract, or I've received demand letters, and they've attached a handbook policy and it says, you violated this policy, we're going to sue you for violating this policy, when the employee has already left. It's not a contract. You can't sue to enforce a handbook after an employee has left. You have some legal protections, whether you have contracts or policies in place or not. Some basic common law claims you see all the time. Duty of loyalty. Every employee has a duty of loyalty to their employer. A lot of employees don't understand this, but they do. You have to act in your employer's interest. You cannot engage in self-dealing, usurping corporate opportunities for yourself. You do get to act in your own self-interest, every employee does, but it has to be consistent, at least while you're employed, with your employer's interests as well. Duty of good faith and fair dealing. Every employment relationship is a contract, whether it's in writing or not, and every contract has an implied duty of good faith and fair dealing. So this common law claim is often used. Interference with business relationships. This is the claim that's usually used to sue the third party that hires your former employee. Have they tortiously interfered with your relationships by misappropriating your confidential information to do it, or by doing something else that may be illegal that makes that interference tortious? And then lastly, conversion, which is just a tort claim, which means taking some property that doesn't belong to you. Typically in the non-compete context, this involves a claim that an employee took some confidential information or laptop or some kind of property that belongs to the employer. The statutory claims that apply, Uniform Trade Secrets Act. This defines trade secret as information that derives value from not being generally known, and information that is actually kept confidential, and that you've actually expended some resources to keep it confidential, and it truly has some value but by not being known, and you've actually taken real steps to protect that information. Criminal theft. Believe it or not, this is sometimes your best remedy. If an employee has taken your laptop, you've asked for it and they won't return it, call the police. It's your property. They need to return it to you. The Computer Fraud and Abuse Act is sometimes used, not so often in the employment context, because it requires you to show that someone basically hacked into your system. And a lot of times employees use the information that they legitimately had access to while employed. They didn't have to hack into your system to get it. So with regard to confidentiality agreements, I just have to plug for my friend Lloyd Cole. He's a 1980s guy. One of his songs, Must You Tell Me All Your Secrets When It's Hard Enough to Love You Knowing Nothing. This applies to employees in the sense that don't share information with employees that they don't need. The thing about confidentiality agreements, it supplements the statutory and common law protections that you already have, and it can expand what we mean by a trade secret. You can define your confidential information and what it is. My caution is don't define it too broadly, and you can't take the word confidential out of confidential information. It's got to be truly confidential. You can require anyone to sign this. Now, can you require a barista at Starbucks to sign it? Frankly, you could. I don't know what confidential information a barista might have, but it's possible that they might. You can't have a barista sign a non-compete. I'll talk about that later. But you can have almost anyone sign it who has access to some information that is actually confidential. In terms of consideration, they have built-in consideration in exchange for continuing working or having access to this information. You agree to keep it confidential. I have never seen a challenge to a confidentiality agreement based on lack of consideration. The biggest problem with these agreements, the biggest challenge, is proving that they breached the confidentiality provision and proving that you actually suffered damages as a result of the breach. Now, as a lawyer, I can contract around that to some extent. I can put liquidated damages in contracts, which I often do in cases like this, and there's ways to handle it, but there are some real serious challenges in enforcing them. The main thing is don't ask courts to protect what you don't. You have to show, if you're ever trying to enforce a confidentiality agreement, that you truly used efforts to keep it confidential. And one of the great things about having confidentiality agreements is that's one of the first things I point to. The fact that you have them at all shows that you're making some effort to keep the information confidential. I've seen cases where people sue or make demand letters against former employees claiming that they have a customer list and they've misappropriated this valuable customer list. The first thing I do is I Google them. I get on the internet and I see their customer list right on their website. it's not confidential. So I love attaching their website to my motion and saying this isn't confidential and the court should throw that case out. And just general practices, disclose information only on a need-to-know basis. Kermit the Frog doesn't necessarily need to know that he's not real. Don't leave laptops and confidential information sitting around. Just this month, there was an audit at the General Services Administration in Washington, D.C. They have a new building. They went in there and there was confidential government information just laying around, laptops open. People would go on breaks and not put a stop on a screensaver up. This is a good opportunity to think about what goes on in your organization. Are people being careful with the information they have access to? Do they lock the drawers that have the information people shouldn't have? Are they leaving their computer open at night so that the cleaning people could take a look if they want? It's a good idea to think about that, because if you ever try to enforce a confidentiality agreement, this is the type of background information that will be used to attack you. We're stepping up now to non-solicit agreements. These are now really my favorite agreements under Oregon law, because Oregon law in 2008 made it a lot easier to get a valid non-solicit agreement. Prior to 2008, you couldn't sign it, you couldn't get one unless an employee, you had them sign it at the beginning of employment or a bona fide advancement. Now you can have an employee sign it any time as long as you give them some real consideration for it. It's also usually tailored to the interest you really need to protect if you combine it with a confidential non-disclosure agreement. And it restricts an employee from soliciting the clients that he or she had access to or obtained confidential information about, or recruiting employees to leave. And usually that's fundamentally the main thing you want to protect. When you try to go beyond that, a lot of times the court will strike down your agreement as violative of public policy, as an illegal restraint on trade. And my speech a lot of times is don't use an overbroad agreement, because the courts are more inclined now than ever to strike them down if you overreach. And so you really have to think about the legitimate interests that you're trying to protect. Under the law, you can only protect your relationships with customers that the employee had access to or confidential information about. You can't put a non-compete restriction on an employee just because they're really good at their job and you don't want their competitor to have access to them. That's an illegal motive, and if it's shown that's the purpose of your non-compete, the court will strike it down. So you have to keep your agreement focused on the protectable interests that the courts will honor. Now, a non-compete is much broader. It takes the employee out of the field altogether. The restrictions that the legislature imposed in 2008 go pretty far. It has to be signed when you start employment or a bona fide advancement. You have to give them at least 2 weeks' notice of the agreement before you hire them, and that's a huge problem for a lot of organizations. They have to be white-collar exempt. They have to have access to confidential trade secret information, and you can only have a 2-year non-compete. And they have to make the median income for a family of 4 based on the latest U.S. Census Bureau, so you have to look that up too. That's around $65,000. So there's a lot of obstacles to getting a non-compete agreement, and that's why I tend to veer toward non-solicits more. And generally, these are all combined in an employment agreement, and there's some other provisions that are very helpful to you. Ownership and return of property and documents. This is a very key provision to put in your employment agreements to make it clear that regardless of the fact that you prepared those bids, or you prepared those proposals, or you collected those cards, or you collected that client information, or whatever it might be, or you prepared these estimates or budgets for us, you did the work, but you did it while we were paying for you, wearing our hat, and it's our property. You don't get to take that with you, and you don't get to destroy that information before you leave. It's important to put those kind of provisions in your agreements if you can. Intellectual property provisions, non-disparagement provision is a very valuable thing to put in your agreement. Employees, well, I haven't had anyone refuse to sign one of these or have any reluctance to. I like to do it one way. I don't like to agree that my organization will not disparage you, because I can't control an entire organization. So I try to make these one-way agreements when it comes to non-disparagement. And then also you can require them to participate in an exit interview and a disclosure of their plans, which is sometimes helpful. I have one case to talk about, just one. There's another one in the materials, but I'm not going to cover it. And this is called TSI v. S&S Electrical and a fellow named Corey Tharp. Sun Tzu is kind of the Bible for litigators in terms of strategy. And this case, like all cases, illustrates the point that you try to win the battle before you fight. And Don't just jump in and make claims without sizing up what your risks are. Going to give you a little bit of detailed background about this. There's three parties that we're really talking about. Technical security integration, they're the plaintiff, they're the former employer who is bringing the lawsuit. They provide security equipment for casinos, in this case, Spirit Mountain in Grand Ronde, and then Three Rivers in Lincoln City. And it works with the manufacturers, in this case, Cinetic Systems, as a certified reseller, and they provide security services on one-year contracts, through one-year contracts. S&S Electrical Contractors, that's the new kid on the block, formed by this fellow named Ben Sullivan in 2010. He'd been in the surveillance industry for 10 years. An interesting fact in the case, in 07-08, he was a project manager for Dynatech, and he was supervising TSI's installation of this Cinetic system that becomes an issue in the case. Corey Tharp, he's the main defendant. He's the former employee that TSI sues. He has a rich resume. It goes back to 1996. He's been in the surveillance industry forever. And he has pre-existing relationships with Spirit Mountain and Three Rivers. I will just tell you, in doing this for a long time, it makes a difference to the courts and juries if you've hired someone fresh out of college or high school or new to the industry, and you teach them the ropes. They're basically your apprentice, and you give them access, and they all develop all these client relationships and business relationships under your wing. Courts treat, and you have them sign a non-compete or a non-solicit. Courts are much more likely to enforce those than they are when you hire a seasoned person who brings a lot of clients, a book of business with them, and they already have contacts in the industry. It's a lot harder to protect those if that person later leaves. In this case is an example of that. So TSI hires him in 2007. He works for 4 years. And in 2011, they give him a pay raise. But there's no change in duties, and this is very significant. This is the first time they have him sign any kind of employment agreement, when they give him this pay raise as a branch manager without an actual promotion. Now, the employment agreement is supported by consideration because it's the consideration was the pay raise. But a non-compete can only be signed if you've already started employment upon a bona fide advancement. This was not a bona fide advancement. The courts make it clear to have one, you got to have three things. You got to have a material increase in pay, a change in title, and a material change in duties and responsibilities. He didn't have that. Now, just a year later, they did promote him to a regional manager position. If they had combined those two into one event, they could have had a valid non-compete with this fellow, but they didn't. Now, they did have a confidentiality and non-solicit agreement as well as a non-compete, and we'll talk about that in a minute. Now, things went downhill as soon as they promoted him to regional manager. He wasn't having as much access to the clients that he really wanted to have access to, Spirit Mountain and Three Rivers, and he didn't like having to travel all over the western United States, and it wasn't a good fit. And shortly after that, some security equipment went missing, and TSI got suspicious about who was involved in that. In November, they fired him. It's sort of that Seinfeld episode where it's not me, it's not you, it's me. We're letting you go because you seem so unhappy with us. Kind of a passive-aggressive reason for letting someone go. And they let him go because it was clear he was unhappy with the direction the company was going. And on December 6th, he signs a severance package that confirms his non-compete and confirms the agreement he signed earlier. Now, we have our Jerry Maguire moment now. You know, all the phone calls when he leaves the agency, we're all now competing for clients. He emails friends and family that he's leaving his status. Employees have a right to do that. Even if they have a non-compete, professionally, you have a right to protect your reputation just by letting people in the industry know what your status is. And then shortly after, he receives an email from Spirit Mountain that says, hey, we'd love to do business with you, whoever you're working for. And Swankowski, the head at TSI, he meets with Spirit Mountain and tries to smooth things over and explain them why they terminated this fellow Tharp, because the folks at Spirit Mountain really liked him. And they told him they did it for performance reasons, because he didn't follow up with clients, wasn't generating new business. And Three Rivers, shortly after getting the email, also invites Tharp to do business with them. So these are two key clients that TSI is about to lose because they let Corey Tharp go, but they've got protection, right? They've got a non-compete, they've got a non-solicit. Okay, I'm sorry about this. This is small print that you won't be able to read in your papers, and I apologize for that, but I just want to give you the background of what happened. So Sullivan, the guy with SNS, the guy who owns SNS, he learns from Spirit Mountain employees that Tharp has left, and he invites Tharp to talk. They talk during the month of December, and they talk about what kind of business they might be able to do together. And Tharp provides to SNS these projections about the money they can make with these two accounts. And according to Tharp, it was just based on his general knowledge of the industry, not based on the projections and the data that he got working for TSI. Now, when he returned his laptop to TSI, he had wiped it completely clean. TSI lost all that data, had to try to recreate it and figure out all the data they needed to assess their relationship with these two clients, these two casinos. They also had a lawyer look at his non-compete and conclude that it was unenforceable. Now, the non-compete part was because they didn't sign it upon a bona fide advancement. SNS ends up hiring Tharp, and then the dominoes start to fall. Click, click, click. Spirit Mountain goes, Three Rivers goes, another client goes, and before you know it, 2013, TSI is kind of out of business when it comes to those casinos. Now, I will tell you that TSI was not sitting on its hands. Sullivan was meeting with his clients, trying to explain why they let this guy go. And he made three different statements to three different he told to three entities. He told Synetics, the manufacturer, that they should stay away from him, that the Oregon Gaming Authority is investigating him for theft, and he'll never get a license in Oregon again. At least that's according to Tharp's allegation. He told Spirit Mountain that Tharp is suspected of theft at the office, and he told Three Rivers that they let him go because he wasn't managing or hiring the right people, didn't manage his time properly, etc. You notice the difference. The first two, they accused him of basically theft. The third one, he just said he wasn't doing very good at his job. That will make a difference later. Pay attention. By April, TSI's had enough. They file a lawsuit, and they sue him for breach of contract, and they sue SNS for interference with its business relations with the casinos. It later adds a couple statutory and common law claims. Tharp counterclaims for defamation per se. If you tell a third party that you are not fit to do your job, or that you have committed a crime and therefore shouldn't be able to do your job, that will be defamation per se. And also for breach of contract, because in the separation agreement where they paid him money, they agreed in that separation agreement that they would not disparage him. I draft separation agreements all the time, and I try to get a one-way disparagement provision. I don't want the organization to commit to not disparaging that person if I can avoid it for reasons like this. Okay, in this case, they move for summary judgment, and we have a jury trial. Summary judgment, here's what happens. I'm going to move through this pretty quickly. SNS and Tharp moved to eliminate the claims. They moved to dismiss the breach of contract claim because it's too broad, should be treated as a non-compete agreement that's illegal under Oregon law. The court says, you know what, we have an exception for non-solicit agreements in the statute, and there's a provision in the agreement separate from the non-compete that says that he won't solicit work on or contact customers, and that can be construed as a non-solicit agreement that is accepted from the statute. So that claim survives. They moved to dismiss the interference claim, and the court said no, a jury could find that Tharp did misappropriate confidential information when he prepared those objections, so that claim goes forward to the jury. It did dismiss the conversion claim based on the fact that he had wiped out his computer, because the court said that if that were the case, then every former employee who failed to leave the proprietary information in a format or in a manner that the employer could easily understand it could potentially be vulnerable to a conversion claim. I'm not sure if I agree with this one based on the facts, but that's what that court decided on summary judgment in this case. They denied the motion to dismiss the trade secret claim because the jury could infer that he stole the confidential information to make the projections. And it denied the motion to dismiss the defamation per se claim because the jury could infer that they had a privilege to explain to these customers why they let him go, and that they didn't go beyond what they needed to say to defend their decision. And then finally, the breach of contract claim survived because he had no proof of damages. Okay. Now, TSI also moved for summary judgment, and the court granted the motion for summary judgment. The court threw it out on the claim that he had defamed Three Rivers. Because remember, all he said to Three Rivers was, we let him go for performance reasons. The court said that's privileged, that's protected. The claim of defamation based on the statements made to Three Rivers, that's out. The jury doesn't even get to hear it. It denied the motion on all the remaining claims because a reasonable jury could find that the defamation claims that the statements about theft went beyond what was necessary to defend TSI's decision to let Tharp go. Okay, I want to back up a little bit. Okay, so most of the claims went forward, but not all. It went to a jury trial. And when after I read the summary judgment decision, I was dying to know what the jury did with this. I wasn't at the trial, but I was very interested because it seems like they had him dead to rights on breaching that non-solicitation provision because the provision said you won't solicit or basically transact business with these two casinos. And what do you think he did? He transacted business with them. Sure he did. He violated that, so what's the consequence going to be? Well, here's what the jury did with it. The jury held that, yes, he did breach that non-solicitation provision, and that non-solicitation provision did survive. There was consideration for it. The non-compete was out, but the non-solicitation provision was there. But they concluded that because TSI didn't sustain any damages as a result of Tharp's solicitation and transaction of business with those casinos. Now, how could they make that conclusion? They probably concluded that because the casino said, look, we weren't going to continue to do business with TSI anyway. As far as we were concerned, we were done with them. They let Tharp go. He was our guy. We were going to terminate our contract whether we continue to work with Tharp or not. This is a chronic problem in these cases. Wherever the clients go, if the clients aren't going to back you up and they're going to say, we would have discontinued our business with you anyway, it's very hard for an organization to prove they were damaged by the breach of the non-solicitation agreement. They also concluded that S&S did not intentionally interfere with TSI's economic relations. On that issue, the jury had to have found, although there was some very good suspicion that he stole that financial information and used it to help provide S&S with projections, it looks like TSI couldn't prove that. And they concluded that Tharp did not misappropriate trade secrets. We don't know whether he did or not, and even if he did, it was too challenging, too difficult to prove it. The jury didn't think that they had enough proof. Now, what do they say? When you spit into the wind, it comes back twice as hard. TSI had to be very disappointed in this outcome because to add insult to injury, the jury concluded that Swankowski did defame Tharp to Spirit Mountain and lost his qualified privilege. That his damages, his per se damages, because if you say someone is not capable or you insult their ability to do their job, or if you say they have a terrible disease, it's defamation per se. So the jury awarded $30,000 in damages for that, $20,000 in damages for the defamatory statements made to Synetics, the manufacturer. And they also concluded that TSI breached the non-disparagement provision in the severance agreement, but that Tharp's damages from that breach were zero. And this is the difference between a defamation claim and a contractual non-disparagement claim. If it's defamation per se, damages are presumed. If it's a contract claim, you have to actually prove that you were damaged. And Lord knows that Tharp was not damaged by that defamation. He still got all the business and ended up winning the day. So getting back to my point, there's layers of protection, good management practices, confidentiality agreements, non-solicitation agreements. You should look at all of the potential layers of protection that you can have and use them effectively to protect your relationships and confidential information. Thank you.